The chair recognizes Representative Jasperse to present the bill. Gentlemen may proceed.
Thank you, Mr. Speaker and House members, for allowing me to present House Bill 875 today. With special thanks to Chairman Powell and the Public Safety and Homeland Security Committee members for their patience and good questions during the past year and a half. And to you, Chairman Meadows, through this adventure, thank you. This bill is, for the most part, a license bill. The Constitution of the United States leaves how one carries weapons to the state to decide. Georgia has a process to be able to carry a weapon in the public by receiving a Georgia weapons carry license. In Georgia, one has to be 21, fill out a detailed application with questions about their past, and then have their fingerprints made and ran through our Georgia Crime Information Center. This application is reviewed by our probate judges. To get this license, one has to be a law-abiding Georgian. Let that sink in just a moment. A law-abiding citizen, the one who pays the bills, have taxes, have kids in schools, volunteers in their state. For their own safety and their families, they choose to carry a weapon. It's their constitutional right. You may decide to do this if you live in an area with violence. You may have been personally threatened in domestic violence. Maybe you don't know, but anyway, it's your right to do so. This bill works to expand where these law-abiding citizens can carry. What we're going to do, because this bill we've been through it twice in the last year, we'll go through it by section, not line by line. So if you'll follow with me, we'll go quickly to 1.2. It's on line 44. This allows citizens to have weapons inside their home if they're in public housing, just like you can't anywhere in your home in our state. Section 1.3. It gives Georgians who are not license holders the same opportunity for immunity using self-defense as a defense as a license holder has. Section 1.4. This allows private property owners their ability to exclude or eject a person who is in possession of a gun or a weapon through the criminal trespass law. Meaning, if you have a weapon, you're asked to leave, you must, or be subject to criminal trespass prosecution. In section 1.5 on line 106, removes in places of worship and bars from unauthorized government locations to private property. I want to take a second to explain this part. All the other unauthorized locations in this code section are true government buildings: a jail, a courthouse, a mental facility, a nuclear power plant, and a polling place. Churches were added in the 1870s to prevent folks from gathering with weapons, where it was a common meeting place. It gave the sheriff a way to enforce a no-gun policy. By moving it, we get governments out of a church's business, as 45 other states do now. The churchgoers totally control what goes on inside of their property. These churches and bars decide what their policy is and do as they choose to enforce it. It's private property. On the next section, we talk about government buildings that all of us good Georgians pay for. If there is not screening by security personnel during the hours it's open for business, you can carry a weapons license. But if it is screened by security, you cannot enter with a weapon. Having security at the door guarantees safety for all inside so that no one is threatened. In any other case, in any other situation, there may be a threat in there. Gun-free zones that are created by well-meaning laws are gun-free to the good guys only. The bad part of our society does not care. This should not prevent law-abiding Georgians from defending themselves. If you look on line 202 and 16, this area is in the school safety zone. And on line 202, instead of a misdemeanor for a license holder to have a weapon on campus of a public technical school, university, or college, the fine shall not be more than $100. Remember who I said was a license holder. Those good Georgians, over 21. If it's not a license holder, it's a felony. And there are other little small changes related to that as you'll read. In section 1.7 on line 342, convicted is for a license to be granted, and this code section will mean a change to adjudication of guilt, so that those Georgians who have been first offenders status and they've done everything required by the court to get their charges dismissed can get their rights back. This is under a judge's control and oversight and is extensive and very well followed. On line 350, we'll allow our service members who have been honorably discharged to obtain a license prior to their 21st birthday. This is a good move. It allows those people then to get jobs in the security business, as you'll see at the end of this bill. The next part we talk about is no license shall be issued to, where you'll see two groups added. On line 402, any person who has been adjudicated mentally incompetent to stand trial, or any person who has been adjudicated not guilty by reason of insanity. Those will not be able to get a license. Those also, you'll see further in the bill, have to be reported within 10 days to GCIC, so we'll have confidence in our license system. This bill also has a provision that for renewal of a license, re-fingerprinting is no longer required. Once you have it done, you're done with that, saving you $45 in renewal fee. Question came up, yes, you do have to have the license redone. Your background will be checked, but we're just not redoing your fingerprints. The bill also prohibits a database from being collected from licensed weapon, licensed carry citizens. In section 1.8, line 579, this is from Chairman Battle's bill that allows a local school board to set a policy where an authorized person can have a weapon to protect the school and its children. The key word is authorized. The school board will set training and practice requirements, approve weapons and ammunition, where and how the weapons should be stored. It's a very local control. It is included that the employee cannot be compelled to do this, and that they can take donations from the public or whomever to accomplish this policy. Because we know there are systems in our state that cannot afford extensive school security. This gives them an option to be able to fulfill that need. Also included in this bill is Chairman Powell's language on airports. It creates a clear penalty under state law for having a weapon in an airport restricted area, and that a person who unknowingly has a weapon can leave without harm if they have a license. This is very similar to our government building penalty, that if they are found at the security checkpoint, they can turn around, retreat, do whatever they want to, mail it back home, take it to their car, miss their flight. It's really up to them. If it's not a license holder, the penalty is different. It is a misdemeanor. And if security there believes that person's there to commit another felony, they can charge them with a felony and do as they wish. There's also an amendment on your desk, AM 28-1296, that clears up a question a few of our members had about when approaching security. Look at section 1.9, it's on 660. It really shows that this clearly is a licensing bill because it restates that you'll have to have your license on you. But also says that the probate judge can now verify it to the sheriff and police when asked. Section 110, it makes clear that the state, we in this room, will be the rulers that make the rules related to the regulation of firearms and other weapons in our state. It prevents the creation of patchwork of different laws, so when a person with a carry license moves throughout our state, they know they're in good shape. We give exception to sheriffs, chiefs of police, commanders of our DNR, Georgia Highway Patrol, and prosecutors to do their own rulemaking as far as weapons go. And we also, down at the end of that little section, give a public remedy to bring action against a county or city for violations of this code section. Both the state and federal law have these fee-shifting provisions, mostly in the area of suits between the citizens and government. Congress and legislatures around the country recognize that citizens and governments have an unequal power when it comes to litigation. This helps to solve that. Section 112 on 765 It reemphasizes that we'd like want probate judges, and they shall report any of their judgments, orders within 10 days to GCIC. I think it's very important they do this because we're finding out that some are and some aren't. So that's why we put the 10-day reporting in there. In section 2.2, we've named this part after Representative Bobby Franklin, who sat right back there for many years and dropped this piece of legislation in for a number of years, and for Dallas Dutton for bringing it up this year. It says that no official or employee of the state during a state of emergency can seize a weapon, a firearm, or ammunition from its citizens, or prohibit the possession of a weapon during a state of emergency. And at the very end in section 3.6, it allows those honorably discharged veterans under 21 to work in the security business. That's why we made that change earlier in the bill. I know I've gone through this rather quickly, I'm sure in some people's opinion. It was essentially the same bill we voted on House Bill 512 last year and Senate Bill 101 last year. And it does give law-abiding Georgians their rights back to carry in more places in our state. And that's it. And thank you, Mr. Speaker. I'll be glad to answer a few questions.
You yield for questions?
Yes, sir, I do.
Looks like you got a few.
I would imagine so.
Well, let's start with the minority leader. Chair recognizes the minority leader of the House, Representative Abrams, to your left for a question.
Thank you, Mr. Speaker. Will the gentleman yield?
Yes, ma'am.
Mr. Jasper, I want to focus on lines 729 through 737 on page 21. I have a couple of questions for you about the private right of action. You
Yes.
referred to fee shifting. Is it not true that when fees are shifted to local governments, that the only source of revenue for local governments are taxpayer dollars?
You're right, but the main key is this thing is that if that local government's a good actor and they follow what we set as the law in this room, that fee shifting will not take place.
Can you show me in the bill where we prohibit frivolous lawsuits from being brought? Because unfortunately, the way our system, I believe, works, a lawsuit can be filed, it can make its way through the court, a local government can be found not guilty, but that does not remove the cost for the actual lawsuit. Can you show me where we prevent frivolous lawsuits in this?
It is not there.
Okay. Can you further tell me how, or actually, is it not true that most counties and municipalities actually hire private attorneys? In fact, we have a number of them who serve in this body because most cities and counties do not have in-house attorneys. Is that not true?
If you state so, I don't know that.
And then is it not further true that private attorneys often charge a market rate, meaning that instead of being able to charge a nominal rate because, for example, I used to serve as a city attorney. I was paid the rate that the city could afford for me. But if I'm a private attorney, I can charge a market rate. Is it not true then that local counties and cities who face these frivolous lawsuits will be forced to pay market rates and thus those costs will be passed on to taxpayers?
I believe that county will make an agreement with the attorneys that defend them and come up with their own fee structure, but that is true.
I think you have a great deal of sorry, I diverged. My last question is, can you speak to why we do not limit the private right of action to only the aggrieved party? And I would direct your attention to line 730 and 731, which specifically talks about the aggrieved person, but also line 729, which essentially allows any person for any reason to sue a county or a city because they believe something has happened without there actually being an action. Can you speak to why we don't create that limit?
Because I think if the citizen sees that their rights are being violated, they either don't do them or they have this right of action to be able to sue them. Do they have to be aggrieved? That means done harm? No, they don't.
So just to be clear, can you explain to me why we are not limiting the ability to sue cities and counties? Let me restate it. Under the terms of this section, is it not true that any person, regardless of whether or not they have been harmed, has the ability to sue a city or a county without having any actual harm caused, to cost the city or county dollars to pay for and defend this lawsuit, and in the end face the possibility of the city or county having incurred cost without having the ability to get any remedy?
Thank you. I believe both parties will have cost, the one suing and the suer, No, we do not limit that. No, ma'am.
Thank you.
Do you further yield?
Yes, sir.
Chair recognizes Representative Lindsay to your left for a question.
Thank you, Mr. Speaker. Will the gentleman yield?
Yes, sir.
Is it not true that we already have under Georgia law sanctions for frivolous lawsuits under OCGA 9-15-14? So that's already been taken care of in regards to the minority leader's concerns.
Thank you, Representative Lindsay.
Do you,
I was about to say, are there no further questions?
well, and the answer is there are. Do you yield for further questions?
Yes, sir, I do.
Chair recognizes the minority whip, Representative Hughley, to your left for a question.
Thank you, Mr. Speaker. Does the gentleman in the well yield?
Yes, ma'am.
Thank you. My question is this. We have just been recognized as one of the best states to do business. How is this law going to enhance that?
I don't think it will unenhance it. I think they're totally unrelated. I think when we look at this bill addresses good Georgians who want to defend themselves with a Georgia weapons license. I think they're totally unrelated.
Does the gentleman further yield?
Yes, ma'am.
Isn't it true that, and let me just say I'm a license holder myself, so I'm one of those good Georgians that you talk about, but if I choose to use that weapon in a way that harms others in violation of the law, then I'm no longer a good Georgian. I'm just somebody who's caused harm to someone else, right?
No, ma'am. That depends on the use of it. I mean, you do have self-defense, as you're aware of, since you do have a license, and you're not a bad Georgian for having to do that.
Well, let me just say one other thing. Isn't it true that I would hate to see Georgia become what we're seeing in Florida with the kinds of cases where people are being killed by law-abiding citizens, right?
I'm not going to say right. That's your statement as you believe.
Do you yield for another question?
I do. Let's have this last one.
Chair recognizes Representative Setzler, or Chairman Setzler, to your right for a question.
Yes, sir.
Does the gentleman yield?
Yes, sir.
Isn't it true that over the last 18 months you have worked extensively with a number of groups to pass a balanced bill that's consistent with the laws in many cases 35, 40, 45 states?
Yes, sir, it is.
Isn't it true that in working with those groups you've taken dozens of hours of feedback and tried to integrate it in a very fair-minded way in this bill?
Yes, sir, I have.
Thank you.
Thank you. Well, Mr. Speaker, I believe we've covered this subject well in the past year and a half. And I yield the well. We have a number of people who'd like to speak to the bill. Thank you.
Gentleman has yielded the well. Shall this bill now pass? All those in favor of the passage of House Bill 875 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 875. The ayes are 119, the nays are 56. This bill, having received the requisite constitutional majority, is therefore passed.